Judge Lyman has grabbed his mop, his broom, his duster, his dustpan, everything you can find, and some trash bags, and he is taking out the trash and cleaning house. Some of these orders are huge, they're big, we've been waiting for them, and they're pretty much going to go ahead and change some people's lives.
There is a moment in every high-profile legal case when the noise stops and the record begins to speak for itself. That moment, in the sprawling and at times chaotic litigation involving Blake Lively and Justin Baldoni, arrived without much warning. Judge Louis Lyman did not hold a press conference. He did not signal anything dramatic was coming. He simply began issuing orders, one after another, clearing out months of accumulated motions like someone who had finally decided enough was enough. And what those orders revealed, taken together, told a story that is worth understanding carefully, because the implications stretch well beyond the two names that have dominated the headlines. This case has never been simple. It has involved publicists, content creators, entertainment executives, record labels, allegations of harassment, counter-allegations of defamation, and an extraordinary attempt by one side to reach into the world of online commentary and compel private individuals to hand over their communications. The docket at one point swelled past 1,000 entries. Lawyers were filing motions on top of motions. Outside parties were trying to insert themselves. The court had become something close to a spectacle. But courts, ultimately, are not spectacles. They are mechanisms. And Judge Lyman, in a concentrated burst of judicial activity, made clear that this particular mechanism was moving toward resolution. If you have been following this case from the beginning, or even if you arrived somewhere in the middle, what happened recently may feel like the end of several storylines at once. That is essentially what it is. And if you find value in this kind of careful breakdown, consider subscribing, because there is more coming in this case and the stories that feed into it, and it is worth having a reliable place to follow them.
Now, granted, all of these are moot, right? They're moot points because Blake Lively and her team eventually withdrew these subpoenas because they realized they were chasing something they were never going to get.
Let's begin with the part of the story that involves people who never wanted to be in it at all. When Blake Lively and her legal team issued a series of subpoenas targeting content creators, people who had been covering the Baldoni dispute on YouTube and other platforms, the reaction across that community was one of genuine alarm. These were not journalists protected by institutional legal departments. These were individual people, many of them operating under their own names or under pseudonyms that were central to how they engaged with their audiences. The subpoenas demanded information. Some demanded identification. And the implicit message, whether intentional or not, was that covering this story critically carried legal risk. Content creators responded the way people do when they feel cornered. They filed motions to quash the subpoenas. They asked to be dismissed from the proceedings entirely.
So that's going to be big for people who wanted to remain anonymous. The judge is saying here they do not have to reveal who they are to the public if they don't want to. There are some creators on here on YouTube and other platforms who were asking to remain anonymous. And these people, it's not like say me, show my face all bold, say my name, and then I'm like, keep me anonymous in the lawsuit. There are people who do content and remain anonymous behind their page.
Some requested the right to continue their work under pseudonyms, arguing that forced identification would cause real harm to their ability to operate safely and independently. The legal term for what they were seeking is protection from compelled disclosure, and courts have recognized in various contexts that the right to speak anonymously, particularly on matters of public concern, is not a trivial one. What makes this chapter of the story interesting is what happened before Judge Lyman even ruled. Blake Lively's team, at some point after issuing the subpoenas, withdrew them. The legal phrase is that they were withdrawn before the opposing parties could fully litigate the challenges. The practical meaning is that Blake Lively's team appears to have concluded that whatever they were hoping to find through those subpoenas was not going to materialize, or that the cost of continuing down that path, legally, reputationally, strategically, was not worth it. So, by the time Judge Lyman addressed these matters in his recent wave of orders, most of them had already become what lawyers call moot. A moot issue is one that no longer requires a live ruling because the underlying dispute has been resolved or abandoned. The subpoenas were gone. The threat, for most of the creators involved, had evaporated. What the judge was doing, in practical terms, was formally closing out the record on these episodes so the docket could be clean.
So the judge basically is like, well, if there's no position, I also have no problem to throw.
And he did. He granted the motions to dismiss. He granted the motions for individuals who wished to remain anonymous, confirming that those parties did not have to publicly identify themselves. He acknowledged the procedural filings by people like the well-known celebrity blogger Perez Hilton, who had attempted to file a motion not just on his own behalf, but on behalf of others who had been subpoenaed alongside him. The judge declined to allow that particular move, noting that Hilton was not a licensed attorney and therefore could not represent other parties in federal litigation. That ruling had no real consequences because, again, the subpoenas were already gone. But it is worth noting because it illustrates something about how courts maintain structure even when underlying disputes dissolve. Now, there were requests for sanctions against Blake Lively in connection with this episode. Some of the affected creators and their attorneys argued that issuing these subpoenas in the first place and then withdrawing them before anyone could challenge them constituted bad faith litigation conduct. The argument was essentially that using a subpoena as a pressure instrument and then pulling it back once the pressure failed to produce results is a form of abuse of the discovery process. Judge Lyman did not agree, at least not in this context. His reasoning was straightforward. The subpoenas were issued, they were withdrawn, and no final harm was demonstrated. He declined to find bad faith on the record as it stood. Blake Lively's team, on this particular point, avoided a formal rebuke. Whether that outcome was the right one is something lawyers and legal observers can debate. What is clear is that the judge did not want to turn a procedural chapter that had already closed into a new front of litigation over sanctions and fees. The broader significance of this episode should not be understated, even if the immediate legal outcome feels anticlimactic. The attempt to use federal subpoenas to pull private content creators into a celebrity defamation dispute was, in the view of many observers, an unusually aggressive tactic. Courts exist partly to serve as a check on that kind of overreach, and the fact that the entire subpoena campaign collapsed without producing any meaningful result for the party that issued it is itself a kind of verdict. Not a legal verdict, but a practical one. The system, in this instance, protected people who had done nothing other than speak publicly about a public dispute. Moving further into the wave of orders that came down, there is a second storyline that deserves close attention, and it involves a figure who has remained somewhat in the background of most public coverage of this case. Leslie Sloan is a publicist. She is, specifically, Blake Lively's publicist, and her name became part of this legal record because Justin Baldoni's legal team drew her into the proceedings as part of a broader claim about a coordinated public relations campaign that Baldoni alleged had been deployed against him. Sloan did not want to be in this lawsuit. She made that clear through her own filings, and once she was in it, she did what any party in that position would do. She asked to be compensated for the cost of defending herself. The legal mechanism for that request is called a motion for attorney's fees. It is not unusual for a party who has been involuntarily dragged into litigation to seek recovery of the legal costs they incurred as a result. The theory is simple. If someone else's lawsuit forced you to hire lawyers and spend money defending yourself, and if the party who created that situation acted improperly, you may have a right to be made whole. Sloan's legal team filed such a motion, seeking approximately $1.3 million in attorney's fees from Justin Baldoni and his representatives. The argument was that Baldoni's team had brought her into the litigation unnecessarily and should be responsible for the financial burden that followed. Judge Lyman's response was not a ruling on the merits of that argument. It was something more procedural and, depending on how you read it, more pointed. The judge determined that the motion had not been filed correctly. There is a specific procedural framework that governs requests for attorney's fees in federal court, and the filing as submitted did not meet those requirements. So the judge denied the motion on those grounds, not without prejudice, meaning the door was left open for the motion to be refiled if the procedural deficiencies could be corrected. That distinction matters. A denial without prejudice is not a final rejection. It is more like a returned assignment with notes. If Sloan's team wants to pursue this, they can try again with a properly structured filing. But whether that will happen is a separate question. The amount at issue is significant. Over $1 million is not a trivial sum, but litigation is expensive, and the decision to continue pursuing fees often comes down to a cold calculation about whether the expected recovery justifies the additional legal cost. There is also a strategic dimension worth considering. Sloan's position in this case has been uncomfortable from the start.
She was pulled in from the outside.
She has every reason to want this chapter of her professional life to be over. Filing a corrected motion for attorney's fees would mean continued engagement with a lawsuit that has already cost her time, money, and presumably some degree of professional stress. The question of whether she pursues it will likely depend on advice from her attorneys and her own assessment of what closure looks like for her. For now, she does not collect $1, and the order, as issued, does not suggest that a corrected filing is imminent. There was also, in this same period, a less prominent but instructive moment involving what is called an amicus brief. An amicus brief is a submission from someone who is not a party to a lawsuit but who wants to offer the court information or perspective that might be relevant to its decision. The term comes from the Latin phrase meaning friend of the court, and in its proper context, an amicus brief is a legitimate and sometimes valuable tool. Public interest organizations, industry groups, and legal scholars often file them in cases that have broad implications beyond the immediate parties. An individual named Thomas Carver asked the court to accept an amicus brief in this case. The subject of his proposed submission had to do with questions about what information should be publicly available in the record and what should remain sealed. These are genuine legal questions in high-profile litigation, where the competing interests of transparency, privacy, and fairness often pull in different directions. Judge Lyman denied the request. His reasoning, at its core, was that this case did not present the kind of circumstances that warrant outside intervention. Amicus participation is generally reserved for situations where a party lacks adequate representation or where the outside party has a substantial and distinct interest in the outcome. A private individual offering general opinions about sealing practices did not meet that standard. The judge was not dismissive in tone, but he was clear. This is not a case that needs additional voices weighing in from the outside. The parties are well represented. The issues will be decided by the court based on the record before it. There is something almost emblematic about that ruling in the context of this entire case. The litigation involving Blake Lively and Justin Baldoni has attracted an enormous amount of public attention. It has generated opinion, analysis, commentary, and what might be called participatory speculation from people who are engaged with it as a cultural story rather than a legal one. The court, in consistently declining to let that external noise affect its proceedings, is doing exactly what courts are supposed to do. The law moves at its own pace and follows its own procedures regardless of how many people are watching. And then there is the matter of Rule 11. If you have not encountered this particular provision of the Federal Rules of Civil Procedure before, it is worth a moment of explanation, because understanding what Rule 11 means in practice helps clarify why the judge's ruling on it carries as much weight as it does. Rule 11 is, in essence, a professional accountability rule. It requires that attorneys who sign and file documents in federal court certify that those documents are not being submitted for improper purposes, not to harass, not to cause unnecessary delay, not to impose needless costs on the opposing party. It also requires that the legal arguments being made have merit under existing law or a non-frivolous argument for changing existing law, and that the factual contentions have evidentiary support or are likely to be supported by evidence after further investigation. When a party alleges that the other side has violated Rule 11, they are making a serious accusation. They are saying, in effect, that the opposing lawyers filed something they should have known was legally or factually indefensible. Courts do not treat these allegations lightly, and they are not granted frequently. But when they are granted, even in part, the message is significant. In this case, the Rule 11 motion arose from claims that Blake Lively and Ryan Reynolds had filed against the parties associated with the film It Ends With Us, specifically producer and defendant Justin Baldoni and figures connected to the film's production and distribution. The claims at issue included civil extortion, tortious interference with contract, and defamation. Baldoni's legal team argued that these claims were baseless and were filed not to vindicate any legitimate legal right, but to harass and to cause financial and reputational harm. Judge Lyman's ruling on this motion was what lawyers would describe as mixed, but the portion that was granted carries real consequences for the narrative of this case. The judge determined that the civil extortion claim had no legal basis. Civil extortion, as a cause of action, has a specific meaning in law, and the conduct that Lively and Reynolds described in their complaint did not meet that definition. The judge was not saying the conduct described never happened. He was saying that even if it did, the law does not characterize it as extortion. That is a meaningful distinction, and it matters because it means the lawyers who sign that claim should have known, or should have investigated carefully enough to know, that the theory was legally unavailing. Similarly, certain contract interference claims were found to lack sufficient factual basis to have been included in the original filing. Now here is where it gets pointed. The judge stopped short of imposing monetary sanctions on the attorneys involved. He did not order Blake Lively's legal team to pay fees or costs to the other side as a result of the Rule 11 violation. What he issued instead was a formal reprimand directed at the law firm responsible for the filings. The firm, identified in the record, received an official finding from a federal judge that it had violated Rule 11 by making claims that were legally frivolous and, factually, without adequate foundation.
A formal judicial reprimand is not the
same as a fine, but it is also not nothing. Federal judges do not reprimand law firms casually. A reprimand becomes part of the record. It is something that the firm's attorneys carry in their professional histories. It is something that can be referenced in future proceedings, in bar proceedings, and in conversations with future clients. It is the court saying, in the most measured and official language available to it, this was wrong, and we are putting that in writing. For Blake Lively, the outcome of the Rule 11 ruling is a complicated one. She did not receive the sanctions she sought against the opposing party. The financial remedy she was asking for, a signal that the other side had been so egregiously wrong that they owed her money, was denied. What she got instead was a finding that her own legal team had overreached. In a case where narrative and perception have been central to both party strategies from the beginning, that is not a neutral outcome. It is worth stepping back at this point and considering what all of these rulings, taken together, actually mean for where this case is heading. Judge Lyman has now resolved a substantial backlog of pending motions. Some of these had been sitting on the docket for 6 months or more. The clearing of that backlog is not incidental. Courts move toward resolution methodically, and when a judge begins addressing accumulated procedural matters at speed, it is generally because the case is approaching a stage where more consequential decisions are imminent. The dispositive motions in this case remain the central thing to watch. Dispositive motions, specifically motions for summary judgment, are requests by one or both parties for the court to decide the case, or significant portions of it, without a full trial. They argue that the undisputed facts, when applied to the relevant law, require a ruling in their favor as a matter of law. If the judge grants summary judgment on key claims, it could resolve substantial parts of this litigation before it ever reaches a jury. The timing of what has just happened strongly suggests those rulings are coming. A judge who has spent weeks clearing procedural debris and resolving long-pending motions is a judge who is making space for the most important decisions. The hearing scheduled for early April was already positioned as a significant moment in the timeline. What has happened in the days leading up to it has only reinforced that sense of a case moving toward its defining phase. What is also worth observing is the cumulative effect of these rulings on the public narrative around this case. Blake Lively entered this dispute with enormous public sympathy following her initial disclosures about her experiences during the filming and promotion of It Ends With Us. That sympathy was real, and it shaped how millions of people understood the conflict. But the legal record as it has developed has complicated that narrative in ways that are difficult to ignore. The subpoena campaign targeting content creators did not produce any results and generated significant criticism. The civil extortion claim against Justin Baldoni's associates was found to be legally unfounded. Her own lawyers were formally reprimanded by the presiding judge for filing claims without adequate legal and factual support. The attorney's fees motion by her publicist was rejected on procedural grounds. None of these outcomes individually constitute a decisive verdict, but together, they represent a pattern that any honest observer of this case has to account for. There is also a broader dimension to this story that extends beyond the specific parties and their specific grievances. The use of discovery subpoenas to compel disclosure from anonymous online commentators is not unique to this case. It is a tactic that has been employed in various forms by corporations, public figures, and private litigants when they believe that anonymous criticism is causing them harm and that they can force identification through legal process. Courts have grappled with this tension for years, and the outcomes have not been uniform. What makes the episode in this case notable is the scale. Multiple content creators received subpoenas simultaneously. The scope of what was being sought appeared designed to map the network of people who had been critical of Lively and supportive of Baldoni online. And the fact that the effort collapsed entirely, that every single subpoena was eventually withdrawn without producing any of the information sought, is a significant data point for anyone thinking about how to evaluate these tactics in the future. The protection of anonymous speech on the internet is not an abstract principle. It is the thing that allows ordinary people to participate in public discourse about public figures without subjecting themselves to the kind of legal and financial exposure that is available almost exclusively to the wealthy. When someone with the resources to mount a federal litigation campaign deploys those resources against individual creators who have no comparable means of self-defense, the asymmetry is stark. Courts serve, among other functions, as a corrective to that asymmetry. And in this instance, whatever the limitations of the individual rulings, the corrective function worked. The content creators who were subpoenaed did not ultimately have to reveal themselves. They did not have to hand over their communications. They did not have to prove, under oath, that their opinions about a celebrity dispute were protected by the First Amendment. They simply had to wait while their lawyers argued, and then they watched the other side walk away without the information it came for. That is not a small thing. And it should not be treated as one. As for where things stand between Justin Baldoni and Blake Lively at the center of this dispute, the core allegations remain unresolved. Baldoni sued Lively and her representatives for defamation and related claims, arguing that a coordinated campaign had been waged against him using media contacts and public relations strategies to shape coverage of the film's promotional period in his disfavor. Lively filed her own claims, alleging sexual harassment and a retaliatory smear campaign. Both sets of allegations are serious. Both parties have presented evidence they believe supports their version of events. The judge has not yet ruled on whether any of those core claims survived a trial. That is the ruling that will matter most, and it has not arrived yet. What has arrived is a cleaner docket, a formal reprimand for one side's legal team, the collapse of an aggressive subpoena strategy, and a pattern of procedural rulings that, while individually nuanced, collectively suggest a court that is not going to reward overreach from either direction. This is what the legal process looks like when it functions as intended. Not dramatic, not swift, not satisfying in the way that a clear verdict satisfies, but functional, methodical, gradually separating what is legally cognizable from what is noise. The April hearing will be watched closely by everyone who has followed this case. If the dispositive motion rulings come before or around that date, the picture will become substantially clearer. At that point, the question will shift from whether the case proceeds to how much of it proceeds and on what terms. For now, what Judge Lyman has accomplished in this recent flurry of orders is to signal, unmistakably, that the case is in its final phase. The procedural landscape has been cleared. The peripheral disputes have been resolved. The parties who wanted out are out. The motions that had been sitting unaddressed have been addressed. What remains is the substance. There is a version of this story in which Blake Lively emerges from the legal process vindicated on her core claims. There is a version in which Justin Baldoni does. There is a version in which both sides lose something significant and walk away carrying legal and reputational costs they did not anticipate. Courts do not often produce clean winners and clean losers in cases this complex. They produce records. They produce findings. And people interpret those findings through whatever lens they brought to the story in the first place. What the legal record cannot be shaped by, ultimately, is public sentiment. It can be influenced by the quality of the evidence and the skill of the attorneys and the judgment of the judge. It can be moved by procedural decisions and strategic choices. But it cannot be won on optics alone. That may be the most important thing this recent round of rulings communicates. The court is not performing. It is deciding. And the decisions it makes will not be governed by who told a more compelling story in the press. They will be governed by what the law requires when applied to the facts as the court finds them. That distinction between the story told publicly and the record built legally is what makes this case worth continuing to follow closely. Because those two things have not always pointed in the same direction, and the gap between them may be about to close. There is a question worth sitting with as all of this continues to unfold. When powerful people use legal mechanisms not just to pursue genuine grievances, but to manage perception, to silence critics, and to shift the narrative, who bears the cost of that strategy when it fails? The lawyers who filed claims without adequate support received a reprimand, not a fine. The individual creators who were subpoenaed spent time, energy, and in some cases legal fees fighting a campaign that was eventually abandoned. The publicist who sought reimbursement for being pulled into someone else's dispute walked away empty-handed on a procedural technicality. In each of these instances, the person or entity with the most resources experienced the most limited consequences. That is not an indictment of any individual ruling. Each of those rulings, evaluated on its own terms, was defensible. But the pattern is worth acknowledging, because the pattern is part of what high-stakes litigation actually looks like in practice. The next round of rulings in this case will address something more fundamental: whether the core claims on either side have enough merit to be decided by a jury. That answer, when it comes, will tell us something important, not just about Blake Lively and Justin Baldoni, but about how courts weigh evidence against narrative in cases where the two have been deliberately conflated from the beginning. If you have found this breakdown useful, the comment section is a good place to continue the conversation. There is more to cover in this case. The Stephanie Jones matter has not been addressed in depth, and the Rule 11 analysis deserves its own dedicated treatment, and those discussions are coming. For now, what Judge Lyman has done is important, and it is worth understanding fully before the next phase of this litigation arrives. The court is not done. Not even close.